versus Michael Tanner Hagel. Mr. Hagel, are you going to hire an attorney to represent you in this matter? You have a motion to adjudicate. Who are you going to hire?
Sir. Nolan White. My granddad has sent the check out. And Nolan is just waiting for the check to go through.
Okay. And you told me that last time, right? That your grandfather was hiring Mr. White for you?
Yes, sir. He just has to send the check from Washington State, so he's just waiting for it to get in and get the process. Then he said he'll come talk to me about everything.
Do you know when it's supposed to get to Mr. White?
My granddad sent it out on Monday, I think, Monday or Tuesday, and just waiting for that to go through.
Okay, I'm going to set you on the contested docket August 28th. Hopefully, Mr. White will get the check and he can get retained, and that'll give him some time to work on your case in the meantime. Okay.
Yes, sir.
If that doesn't happen, then you need to notify somebody at the jail so that we can figure something out before then.
Yes, sir. Thank you, ma'am.
Thank you. Okay, Mr. Manning is ready.
Who would you like first, Mr. Manning?
Judge, if we can pull Mr. Rosas.
Leonardo Daniel Rosas, CR 21-391. It's my understanding that there's an agreement between the state and defense. I believe the state has filed a motion to withdraw its motion to adjudicate and to continue Mr. Rosas on community supervision with 180 days in jail as a condition. Is that correct?
Judge, that and he is going to participate in Collin County's intensive supervised probation and do that program in Collin County.
Is that a condition also here in Vincent County?
Yes, yes, Judge.
All right, Mr. Rosas, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, Mr. Rosas, this agreement that you've entered into with the state, anyone threatened, forced, or pressured you to do that?
No, sir.
And are you pleased with Mr. Manning as your attorney and the work that he's done for you?
Yes, sir. I am.
Do you have any questions about this agreement?
No, sir.
Do you understand, Mr. Rosas, that this 180 days of jail time that you have to do you understand that should you be revoked at a later date and sentenced to prison, you will not get credit for any of those days that you're doing as a condition here during this amendment?
And Judge, if I may just clarify, he has credit for the 180 days. The dates for that are August 8th of 2023 to February 2nd of 2024.
Yeah, I'm aware that he has credit. I just want to make sure he understands that he will not receive credit should he receive a revocation order that sends him to prison. Do you understand that, Mr. Rosas?
Yes, sir. It's 2 years, correct? Because, and 2027. Should I create that right now? Start 2 years from now and 2 years. Your term hasn't changed. Whatever you originally signed for.
Any questions, Mr. Rosas?
No, sir.
Okay, so you do understand that if you get another motion to revoke, and if this court hears it and determines that you violated the terms and conditions of your probation, if I revoke your community supervision in the future and I sentence you to prison, you will not get credit for these days that are outlined in that motion in order to withdraw. Do you understand that?
Yes, sir.
Okay, and do you still wish to go forward with the plea?
Yes, sir.
Any questions? You seem like you're a little bit hesitant.
Well, no, just about the I signed for 2 years initially. Is the 2 years beginning today or beginning from when I signed previously?
You're going to give me a moment to pull up your rights and procedure to Mr. Rosas.
Yes, Judge, I've explained that we could have a hearing on this. The judge could sentence, the judge could sentence him up to 2 years, and that he is giving up a right to hearing on that in order to take this.
Okay, all right, then, the court finds that Mr. Rosas, having the assistance of counsel, has entered into an agreement intentionally, knowingly, voluntarily. Court is granting the state's motion to withdraw its motion to adjudicate. The court will continue Mr. Rosas on community supervision, order him to pay $500 in attorney fees, order him to serve 180 days in jail as a condition of community supervision. The court will give him credit for time served on that. All right, Mr. Rosas, I would recommend this be your last time that you're on a motion in this court. Do you understand?
Yes, sir.
All right.
Thank you, Mr. Mayor.
Who's next, Mr. Mayor?
Judge, next we're gonna Miss Lena Price.
Ms. Price? Cause number CR 21-88, State versus Lena Marie Price. All right, looks like we have a similar agreement for Ms. Price. State's wanting to withdraw its motion to revoke, wants to continue Ms. Price on community supervision with placement on intensive supervision, and order her to pay an additional $500 in attorney fees as a condition due to the
Yes.
motion filed. Is that correct?
Yes, Judge, and a slight difference between Mr. Rosas and Ms. Price's case. She was well on her way to doing what she needed to on probation, but through some family tragedy and some stuff going on, she just relapsed, and she recognizes that that's unacceptable since she's on felony probation. She's ready to tackle the ISP and get things straightened out and finish out strong.
All right, Ms. Price, raise your right hand. I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. All right, Lena, you and I, we've had a lot of hearings together through sanctions court and other. You understand that your rope is very short at this point.
Yes, sir.
I understand that addiction is a lifelong disease. I understand that relapse is a part of it, but you understand that relapsing while you're on felony probation, not a whole lot of grace to be given on that. You understand that?
Yes, sir.
So this is the time. This is going to be your last time.
Yes, sir.
I'm not going to put you back on and continue to have you doing drugs. If that's what we're going to do, I'll just revoke you. You'll go serve your sentence.
Yes, sir. No, I'm gonna stay clean, sir, and hit strong out there.
All right, court will grant the motion to withdraw. Court will continue Ms. Price on community supervision, places her on the intensive supervision program, and orders her to pay $500 towards attorney fees for the filing of the motion to revoke.
Judge, as you may recall, on Mr. English's case, we were waiting on a DWI third or more that was he was arrested on. At this time, the state has, my understanding is the state has still not indicted that case, and so we're going to request a agreed PR bond for the DWI third or more, and we will announce ready on the assault cause family member, household member with previous conviction asked for a trial setting in that case.
And Your Honor, that's correct. The DWI third has been under attorney review, has not yet been presented to the grand jury. I believe the 90 days is up tomorrow or Saturday. So obviously we don't have a grand jury setting before then. So state would concede that Mr. English is entitled to a PR bond on the DWI third.
Okay, so either a writ will have to be filed or you'll have to contact the justice of the peace who did the magistration. I don't have jurisdiction over it if it's not filed.
Judge, what I can do is I can file an agreed order under the writ under a writ number, and my understanding is that the clerks can get that file where it needs to go.
Yeah, if you file the writ, that will invoke my jurisdiction and then I will review it.
Thank you, Judge.
All right, and so Mr. English is, you said rejecting all offers at this point?
That's correct, Judge.
And Mr. Hartwell, is there an offer that was provided to Mr. English?
I believe there was, Your Honor, if I could have just a moment to look it up.
Do you know what it was, Mr. Manning, off the top of your head?
Judge, we had been discussing the assault case prior to his picking up the new offense. And at that point in time, Mr. English maintained his innocence and was requesting a jury's selection. I know the state made a combined offer, which was a significant amount of prison time. And that was the most recent offer that we rejected.
That's correct, Your Honor. The state's offer was for a global resolution for 15 years TDCJ.
Was there a different offer made, not considering the unindicted DWI?
No, Your Honor. I believe the only offer that went out was the global resolution.
Okay. All right, court will place Mr. English on the court's trial docket beginning August 4th. And once he reaches the top 10, Mr. Manning, you'll be notified.
Thank you, Judge.
Time to break this one down. This courtroom session had a little bit of everything. Hopeful promises, legal wrangling, a touch of family drama, and more than one defendant hearing what very well may be their final warning. First up was Michael, Tanner Hagel, who's waiting on his grandfather's check to clear so he can retain an attorney. The judge gave him a reasonable window August 28th and made it clear, if the money doesn't come through and an attorney doesn't show up, the court needs to know ahead of time. You get the sense the judge has heard this story before, and while he was patient, that patience may not last forever. Then we had Leonardo Daniel Rosas, who entered into an agreement with the state to withdraw a motion to adjudicate, continue, on probation, and serve 180 days in jail with credit for time served. It's a fair deal, especially considering the judge went out of his way to make sure Rosas understood that this time won't count toward a future prison sentence if he gets revoked on the line. Mr. Rosas seemed a bit unsure about the timing of his sentence, but once clarified, he agreed. Judge Martin was clear, firm, and more than fair here, making sure the terms were crystal clear while keeping the tone respectful. That leads us to Lena Marie Price, whose situation was strikingly human. She relapsed due to a family tragedy while already on felony probation. Her attorney vouched for her progress and readiness to recommit, and Judge Martin made it very clear there's empathy for addiction, but not a lot of runway left. He gave her another chance with intensive supervision and tacked on $500 in attorney fees. The judge didn't scold, he leveled with her. It was one of those moments where the court felt like a human space, not just a legal one. Finally, we had Mr. English still holding out for a jury trial while the DWI charge is still in limbo. The previous offer? 15 years TDCJ for a global resolution. That was rejected, and now he's on the trial docket. The state acknowledged the grand jury hasn't indicted the new charge yet, so they agreed to a PR bond. The whole thing wrapped with the judge reminding counsel that he can't act on the unfiled case unless a writ is properly submitted. Once again, Judge Martin kept things organized, fair, and procedurally sound. The courtroom atmosphere was steady throughout, with Judge Martin striking the right balance between compassion and accountability. Whether he was dealing with check delays, credit calculations, or final chances, he maintained control and clarity. At every step, if you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.